Good afternoon. Please be seated. Welcome to Division 7 of the Colorado Court of Appeals and to the Ralph Carr Judicial Center. I am Judge Dunn. I'll be presiding today, and serving with me today is Judge Berger on my right, and we welcome Senior Judge Casebolt on my left. Today we have two cases on our 1:30 docket. The first is People v. Johnson. Counsel are present and ready, I see. Our second case is Blakely v. BNSF Railway. Are counsel present for that case?
Yes, Your Honor.
All right, we will not take a break between the two, so when counsel departs on this case, you may come up and be prepared. Counsel, I know in Johnson you're both experienced. Do you have any questions about oral argument procedures? All right. To our visitors today, we live stream and record our oral arguments. With our recording equipment, we would ask that you not just silence your personal electronic devices, but turn them off. They interfere with our recording equipment. Thank you for that. And counsel, as you know, if there's anything confidential in your arguments, it's all being recorded, live streamed, and will be available on the website. So conduct your arguments accordingly if there's anything that you're concerned about from a confidentiality perspective. And with that, counsel, we may start People v. Johnson.
Good afternoon. May it please the court. My name is Lynn Nesner, attorney registration 39209. I'm here on behalf of the defendant appellant, Mr. Johnson. I'm going to be focusing on the first issue. 15 years ago, a division of this court in Mullins held it's improper to admit evidence regarding the process for obtaining a warrant. Division reasoned that whether a judge finds probable cause has no rational tendency to establish whether a defendant committed a crime. Such evidence is irrelevant and misleads the jury about the importance of the arrest and charges. It erodes the presumption of innocence, which is an essential feature of a fair trial, by conveying the judge's belief in the defendant's guilt. The facts of this case are analogous to those in Mullins, except this case involves worse facts, in that the prosecutor elicited testimony from two separate witnesses regarding the warrant process. This wasn't a fleeting reference. This was multiple references to probable cause or judicial approval of the police actions from two separate witnesses over multiple pages of transcripts. The prosecutor asked Detective DeMonico to educate the jury regarding what an arrest warrant is. He responded, "It's a story of what happened." He discussed the info he included in the affidavit, why he suspected Mr. Johnson, and indicated the judge agreed with him and signed the warrant, making it legal.
Ms. Nestor, but wasn't the error mitigated when Detective Delmonico said to the jury that while they had enough to get an arrest warrant, there wasn't enough to charge the defendant?
Detective DeMonico provided this sort of running commentary on his investigation. He said initially when they made the connection to Mr. Johnson's car, Mr. Johnson had a dark Volvo, which was somewhat similar to the vehicle that may have been involved in the robberies, that wasn't enough for an arrest warrant. But then once Mr. Flores identified Mr. Johnson, he acted like that was the linchpin that then they could get an arrest warrant, even though the identification of Mr. Johnson by Mr. Flores was, he said he was only 25% certain. And then he said, once they did the search, he had enough evidence for the charges. So he's providing like sort of this commentary on the credibility and validity of his investigation, with the conclusion being, by the end of the searches, we had enough for the charges and we got the right guy. This was the message that was conveyed. But his opinion on his investigation isn't really relevant. So, I mean, and the prosecutor also, while he's saying, well, we didn't have enough evidence at this step, is saying, but you had judicial finding of probable cause, right? I mean, the prosecutor is mentioning probable cause multiple times. So I don't think it was mitigated, also because the ultimate message conveyed to the jury was, we had enough for the charges. And I think the larger problem with why this evidence was so harmful, I mean, because you have it from the two witnesses. In addition to Detective DeMonico, you also have Officer Wiley providing similar testimony about the process for obtaining a warrant and how if the judge doesn't find probable cause, the suspect in evidence will be released. Here, obviously, Mr. Johnson wasn't released. None of this evidence was relevant, but the state needed it to sort of like legitimize its case because there was a dearth of actual evidence against Mr. Johnson. That's why this isn't like, there's many divisions of the Court of Appeals that the Attorney General relies on in his briefing where they've said, oh, this is fleeting or it's not that harmful. But in this case, it's really harmful because the state didn't have very much evidence against Mr. Johnson.
What evidence, how would you describe the inculpatory evidence? What inculpatory evidence was there from your perspective?
There was very little inculpatory evidence. I would say, they originally, Detective DeMonico was looking for an African-American male who had a dark Volvo, but the eyewitnesses who identified the Volvo, they said that the Volvo was black or blue, a 2003 V50 Volvo. Mr. Johnson had a 2001 brown V70 Volvo, so it's somewhat similar. So they have that connection. And then, the state had a gun, but the gun they didn't even identify as belonging to Mr. Johnson or being registered to him. That was about it. And I guess there was rubber gloves that they found in his house, but I have rubber gloves in my house. That's about it. And Mr. Flores' identification of him was a really, like I said, linchpin that they relied on, even though, I think the part of the problem with the Detective DeMonico providing this commentary on his investigation is also then it's not leaving for the jury to decide. Jury should decide what is this weight of this identification. The jury should decide what is the weight of the items that they found in the search. But this detective is providing this commentary of, then we could charge him, and then the judge approved of this.
Ms. Nesner, let's assume for purposes of my question only that we agree that it was improperly admitted, and we agree that the error might be plain in view of the case law. Help me understand why it's nevertheless plain error in this circumstance and not and sufficient to get over that hurdle.
I think it was obvious because Mullins had been well-established law for some period of time, close to, 10 years at least at trial, and it should have been obvious under the rules of evidence. It's also substantial because we're talking about the presumption of innocence. And in Mullins and Cook, the divisions, they looked also to the quantum of evidence that the state had against Mr. Johnson.
Well, can I stop you there? Because one of the instructions the court gives, is it not, is to say the charges against the defendant are not evidence. So just the fact that they were able to get a warrant, you're saying?
It's the testimony that they heard that from, over 8 pages of transcripts that, and the prosecutors reminded him, and the judge found probable cause. It's this idea in the back of a lot of jurors' minds that, well, he wouldn't be sitting there if he didn't do something. And it's sort of feeding off of that assumption, that is not the principle that our criminal law is based on. We start with the presumption of innocence at the beginning of trial. And this instruction, I don't think, is enough when the state is really using this evidence, too. It's also so I think the evidence the state had against Mr. Johnson was really weak, which I can talk about a little bit more. But also the state used this evidence to kind of legitimize its case. And in closing argument, they say, this case is about good police work. Detective Delmonico got the right guy. And they talk about how thorough his investigation was. And having all this discussion about how they obtained the arrest warrant and then they obtained the search warrant is making it seem like, well, the police jumped through all these hoops and the judge believed that he was guilty. So, well, then we should believe he's guilty. And this is a case where during trial, a juror sends out a question to Detective Delmonico. What is the exact link between Mr. Johnson and the charged offenses? That's a testament to how weak the evidence was. Mr. Johnson has a lazy eye, and the only visible part of the suspect was his eyes. And none of the charged victims said that the suspect had a lazy eye. That's a pretty noticeable predominant feature. And none of them identified the suspect as having a lazy eye. None of them really, some of the victims said that the suspect was short and stout. Mr. Johnson isn't short and stout. And most of the victims couldn't identify Mr. Johnson. The one that could was only 25% certain. And then you don't have DNA linking him to any of the robberies. You don't have inculpatory statements. You don't have actual evidence. So this is why the state's telling the jury, well, this case is about good police work. And look how all the steps the police did to make sure he was the right guy, including going to the judge and getting these warrants.
Well, Ms. Nesner, I didn't see any in closing argument that referred at all to the warrant process or the search warrant or the arrest warrant.
The theme of the closing argument was that this case was about good police work, which I think in a case where there's actually good police work, you don't need to tell the jury that. It's obvious. The evidence speaks for itself. I think they're telling the jury that because there's a real question about whether that Mr. Johnson is actually the perpetrator. And they did mention, and when I went back to look in prepping for oral argument, they did mention probable cause once on page 118. It was February 19th. It mentioned that Detective Delmonico had court authority and probable cause to enter a defendant's house. But I think the bigger picture is that they're painting this picture of the police investigation as being really legitimate, and they're sort of padding their case with this testimony that's improper. And in a case where Mr. Johnson may have been wrongfully convicted, there's not a ton of evidence to suggest that he's actually the right guy, but they're saying, we got the right guy, look, and the judge believes us. And that's why this case is different, because the weakness of the evidence and how they needed it to legitimize what their lack of otherwise what would be evidence against a defendant.
Did you argue that there was cumulative error?
I did not. I think that there's a lot of problems with Detective Delmonico's testimony, which is raised in the first two issues in the brief. I mean, I think his testimony is also improper under Salcedo. And I think all of it does combine together. There was a lot of evidentiary errors, which are sort of separate from the sufficiency problems that are raised in the third and fourth issues. If this court doesn't have any further questions, I'll reserve the rest for rebuttal.
All right, thank you, Ms. Nesner.
May it please the court, my name is Jacob Lofgren, registration number 40904, and I represent the appellee, the people of the state of Colorado. This court should affirm the defendant's convictions because the officer's brief reference to probable cause to get an arrest warrant and probable cause to get a search warrant was fleeting and brief and generic in this case, and it did not substantially undermine the convictions to the extent it was improperly admitted.
But you agree that it was improper?
I think under Mullins, the standard would be very hard to show that probable cause is ever at issue in a case like this. So I think I would concede that point. But I think in this case, it certainly wasn't plain air. What we're talking about is very brief statements over the course of 8 pages. And we're not talking an 8-page narrative. When I cited 8 pages in my brief, it was bits and pieces throughout those 8 pages. All the officer really says is, look, I got a stack of cases on my desk. I looked through them. I found some things that looked similar, and that was enough for me to get an arrest warrant. But as Judge Berger pointed out, he specifically says, an arrest is not enough to get charges. An arrest is not enough to get a conviction. He makes that very clear for the jury. So to the extent this was at all improper, he certainly clarifies for the jury that what he is saying is not enough for them to return a guilty verdict on its own.
Mr. Lofgren, can you tell us what you think the inculpatory evidence was?
Yes, I think opposing counsel did a pretty good job laying out the key pieces. The dark-colored Volvo, which was what tied all of these cases together and eventually led to the defendant. During the search of his house, they found a gun that had his DNA on it that was similar to the gun used in the robberies, as described by each of the eyewitnesses.
Well, his DNA, I mean, that doesn't mean anything. If he had the gun, it would have his DNA on it.
Right. I'm just,
Doesn't tie it to the crimes.
the reason I point that out is at trial, the defense makes a big deal out of the fact that there is no way to say that this gun is for sure his. And the DNA does tie that gun to him. Then the witnesses to each of the robberies also say that gun looks like the one that was used in these robberies. It looks similar to the ones that is seen in each of the surveillance videos. So I think those are the two key pieces. The third piece of evidence is the eyewitness identification of the defendant in the photographic array. And while he does express some hesitation, and he's not 100% equivocal that this is the guy, that is a piece of evidence that suggested the defendant was the person who committed these robberies, particularly the three that are at issue.
The 25% bothers me a lot because he's the only witness who can link defendant to these three crimes, right? In terms of identification.
That's correct.
So he's saying, I'm only 25% sure that this is the person who perpetrated the third robbery.
Right, he expresses that hesitation. I don't contend that that's not that case, but I think that piece of evidence coupled with the defendant driving the Volvo that's similar to the one seen near the scenes, and the evidence recovered from his house, the backpack, the gun, the rubber gloves, all of those things taken together is more than sufficient to support these verdicts, and it also is enough to say any error in admitting this very brief testimony about probable cause couldn't have been plain. It certainly wasn't so substantial as to undermine the verdicts.
What was the relevance of having one of the detectives testify about the fugitive unit and suggesting that the defendant was armed and dangerous? What possible relevance did that have to prove his guilt of these crimes?
Right, so in terms of saying fugitive unit, I disagree with opposing counsel's assertion that the way that was used at trial was to suggest that this was a bad guy or a dangerous guy. All the officer really said is, I am a member of the fugitive unit, my unit affected this arrest. That is the way that was used. The extensive discussion that Officer Wiley has when he is describing the arrest is important here because the defendant's theory, or part of his theory at trial, was nothing really connects me to that house where I was found at. That's my wife's house, I was just there watching my kids. And so Officer Wiley's testimony, that I think is about 20 or 25 pages long, about affecting the arrest, describes him sitting outside the house. The defendant was there for several hours. He had a connection to it. He came out and got in the Volvo and drove around for a little while. He came back to that house, and that's where the arrest was affected. I think it's that fact that Officer Wiley's testimony was being offered to combat the defendant's theory that he had no real connection to this house and anything found in it wasn't connected to him. Officer Wiley's testimony that I was there for several hours, he was there for several hours, kind of combats and defeats that theory. I think that's why it's relevant.
Was there any, let's talk about, although opposing counsel didn't raise it, let's talk a little bit about the pattern issue. Is the only thing that I can see that links him to the previous two robberies is the pattern evidence. The evidence that a similar person comes in at closing, person's coming in either the first of the month, middle of the month, last of the month when they supposedly need money or could need money. Using the same kind of mask and cap and taking them back to the restroom and moving them back there and taking cell phones. And those things seem pretty distinctive. But what bothers me here is that the police officer is the only one linking those three, isn't he?
Well, I would say that there is one robbery that has stronger evidence, the one where the victim does ID the defendant. And the police officer, Detective Delmonico, does tie them together. But what he does is not anything beyond what an ordinary juror could do on its own. The sole reason Detective Delmonico is the only officer to do that is because he was the officer controlling this case. I think as he describes it at trial, he's kind of given a stack of pending and open robberies, and he flips through them looking for similarities. And when he finds some similarities, he kind of tries to tie them together for purposes of the investigation, which is what led to the Volvo in this case, et cetera, et cetera. So what he is offering here isn't expert testimony, especially not the way he does it. All he is essentially saying is, look, the reason we were able to put these together is because in each instance, the same thing happened, or at least pretty close to the same thing happened, including most specifically at the end of the robbery, taking them to the bathroom, telling them to count to 100, and then escaping while that occurred. I don't know if that addresses your question.
Well, it doesn't, it doesn't. I mean, it seems like it's, if the jury could draw that conclusion, why did they need the officer to talk about these supposed patterns? What relevance does it make when the officer is saying, these are a pattern, but then there's a lot of things that dictate not a pattern, right?
I wouldn't say a lot of things that dictate not a pattern. There are certainly some minor dissimilarities, and defense counsel did a really good job of pointing those out below, which I think is part of the reason they spent so much time on this description of the similarities between them, because it was clear the defendant's theory was these aren't similar, so don't convict me of one or any of them. And in fact, if I remember correctly, defense counsel introduced some of her own 404B in order to combat the idea that these were similar. She did that both at the first trial and at the second trial. And I think that's the reason they spent so much time with Detective Delmonico going through these similarities. And the thing I would pause to point out here is, while this is phrased as kind of a pattern discussion, that word isn't used a ton of times at trial. More what Detective Delmonico is doing is just pointing out those similarities, and occasionally there's a reference to the fact that that is a pattern.
Do you agree that some of the officer testimony was improper lay testimony? In other words, it was in fact expert testimony that should have resulted in a pretrial disclosure?
Detective Delmonico is about the pattern? I don't. I don't agree that this is expert testimony here, because an ordinary person using their common experience and knowledge can say this thing looks like that thing. And that's all that happened here.
Well, what about, I think it was Delmonico's testimony that robberies typically occur on certain days of the month. He went into a lot of detail about robberies generally.
I'd push back on the lot of detail. The portion of his testimony you're talking about, I think, is 4 or 5 pages. I counted this morning at the very beginning of his
But
testimony.
isn't that expert testimony? I mean, the normal person in the street doesn't know what the likelihood of a robbery, of an armed robbery is on any given day of the month.
I think it approaches the line, but the reason I don't think it is in this case, or at least is not obviously expert in this case, is because the factors he's describing are present in this case. Robberies tend to happen on the end of, at the end of the month. All 3 of the robberies charged in this case happened at the end of the month. Robberies tend to involve someone, I'm trying to think of the other things he described. Point being, the things he describes in that portion of the testimony you're identifying, that 4 pages, all relate to this case and all relate to his use of the similarities in this case to form this kind of connection between the 3. And the other thing I would point out about that connection is all Detective Delmonico is doing is saying these 3 robberies look similar. At no point does he say, because these 3 robberies look similar, you have to convict the defendant, or the defendant is the person that did it. It is different evidence, separate evidence, that brings the jury to the conclusion that the defendant is the person that committed them. All Detective Delmonico says is these 3 robberies look similar. If this court has no further questions.
Actually, Mr. Hoffman,
Yeah.
I want to jump over to the first-degree kidnapping.
Okay.
Because as I read your brief, you're saying there is substantial evidence, or there is evidence that supports the element of concession, and I didn't see any testimony or evidence to show concession. So why isn't this second-degree kidnapping?
Well, I would make 2 points. First is second-degree kidnapping is certainly satisfied here, and that would be the people's position if all else fails. I do think, and I recognize there's a tough row to hoe here with first-degree kidnapping. What I would say is the robbery, the primary robbery, is complete once the defendant gets the money from the safe, gets the money from the cash register. The kidnapping, the concession, the movement happens when he takes them from the front of the store to the back, says, "Give me your phones." That's the concession he's getting, and puts them in that bathroom so that he can escape.
But doesn't the Supreme Court in Bridges say that's not enough? It's not, as a victim of a robbery to hand something over, that's not enough?
I
For the
agree.
concession, oh, you agree, okay.
Yep.
And I appreciate your frankness, okay.
Mr. Lofgren, can we consider cumulative error?
Sua sponte, not raised. I can't think of a case off the top of my head where this court has done that, but I don't know that there's a reason that I can specifically stand in front of you and say no.
I take it that you would disagree that there was cumulative error.
I would disagree there's cumulative error because I disagree that there are any errors in this case with respect to the evidentiary issues.
Well, I thought you conceded that the probable cause testimony was probably
That's
error.
true. That's true. I would say to the extent that was error but not plain. If there are no further questions, I would ask this court to affirm.
Thank you. Ms. Nesner, you have 3 minutes and 39 seconds for rebuttal.
First, to touch back on Detective Wiley's testimony about the arrest of Mr. Johnson, I don't think that he needed to go into all of the steps he took to arrest Mr. Johnson in order to, even if it had some relevance, they need to show, oh, Mr. Johnson did in fact live here. And I think they introduced mail that also served that purpose. But his testimony about the precautions he took, including performing surveillance and assessing for obstacles and waiting for backup because he didn't feel safe contacting Mr. Johnson without like a team of armed uniformed police, that just amounted to a gratuitous character attack, which I think goes, I mean, all the stuff, I think this court can consider all the evidentiary errors together as they work without even an express cumulative argument. I think reversal is required as to both evidentiary issues, and the conviction should be vacated pursuant to the sufficiency arguments, but it's all part of sort of this testimony that this, particularly Detective Delmonico, gave that was problematic. As to the second issue, I think he did provide expert evidence. The prosecution was relying on his expertise in investigating murders and robberies, and asked him how many robberies he had investigated. And then based on this expertise, he's articulating this profile of a robber, MO testimony, a profile similar to that in Salcedo. But the problem is that there was no pretrial notice of his expert opinions, and we didn't really have a chance then to challenge them. And what he gives is a lot of sort of anecdotal testimony. I would say that's not that reliable, that if we'd had pretrial notice, we'd be better equipped to challenge it.
But there wasn't an objection, was there?
No, there wasn't. No.
And Ms. Nesner, the jury also heard from all of the victims who laid out some pretty basic commonalities that the jury could draw their own conclusions, that there were similar, a person came in wearing similar clothing, they demanded cell phones, they moved them to the back, they asked them to count to 100. I mean, isn't that, some of that testimony is just common sense that a jury could conclude on its own based on the victim's testimony?
Correct, but then the Detective Delmonico was adding this sort of veneer of like, he added this sort of expert so that they could trust his opinion that they were all connected. And he also added sort of irrelevant kind of stuff like, well, robbers are often on drugs and they're unsafe and they go to the same auto parts shops because they're laid out the same, but they weren't, and they commit robberies at the beginning, middle, and end. So he added a lot of sort of irrelevant stuff to the description of the pattern that I think then harmed Mr. Johnson. I see my time's elapsed. I would ask that this court reverses on the first two issues and vacates Mr. Johnson's convictions based on the sufficiency arguments.
Thank you. Thank you both, counsel, for your helpful arguments today. We appreciate it. People v. Johnson will stand submitted, and an opinion will issue in due course. And once counsel departs, counsel for our next case may come up front. Counsel, while you're setting up, do you have any questions about our oral argument procedures?
No, Your Honor.
All right. Then counsel for Mr. Blakesley, you may proceed when you're ready.
Thank you. Before I begin, may I introduce the court to my co-counsel, Steve York. My name's John Case, registration number 2431. Next to Mr. York is Richard Blakesley, the plaintiff appellant. And in the first row over here, we have Mr. Blakesley's family, his wife Amanda, and his two children, Tyler and Avery, both students at Heritage. Your Honor, Counsel Mr. Widman and Mr. Fowler, this appeal is based on legal principle that misfeasance by an actor gives rise to a duty to protect others. The misfeasance that caused Mr. Blakesley's injury was Mr. Gallowix telling Mr. Blakesley not to wear a high visibility orange safety vest. There were two safety rules that were in play on the morning of June 4th, 2012 in the construction zone where the railroad tracks cross Old Wadsworth Boulevard in Arvada. The first rule is intended to protect every worker in the construction zone. And by the way, that construction site is about the size of this courtroom, 35 by 35. Everyone on the job site must wear a high visibility orange vest because there's a very dangerous piece of machinery there, which is the excavator or track hoe, which is a...
Who promulgated that rule, the high visibility vest rule?
It's a standard OSHA rule, but it was promulgated by Mr. Gallowix. And the trial court found that. She said, quote, "The flagger told the plaintiff to wear a safety vest, as he did with every single person working on the site." That is at page 9 of the court's order. The purpose of that rule is to protect the construction workers from being run over by that machine. Now, the second safety rule protects only welders. And that is, welders have to wear fireproof clothing. On June 4th, 2012, Mr. Blakely was the only worker who was required to comply with both rules to protect his safety.
Mr. Case?
Yes, sir.
You said that the misfeasance is don't wear a safety vest.
Yes.
But my recollection of the record is that the flagger said, anytime you're not welding, you wear a safety vest. How do you reconcile those two?
Good question. So let me read the exact quote where what Mr. Gallowix, this is cited in the briefs, what Mr. Gallowix told Mr. Blakesley was the safety vest wasn't necessary as long as I was wearing my helmet and leathers. The safety vest wasn't necessary as long as I was wearing my helmet and leathers.
Is that because the safety vest was flammable?
Yes.
So wasn't part of the risk that there would be a personal injury to Mr. Blakesley if he donned and wore the safety vest while he was welding?
Yes.
So you said the BNSF flagger said, don't wear a safety vest, but that was relevant only to the welding part, was it not?
Well, that's what Mr. Blakesley was doing on the job.
But didn't the trial court find that, and isn't it undisputed, and this is more important, that he wasn't injured when he was actually welding?
That is not undisputed. It is disputed. First of all, the conversation was the safety vest wasn't necessary as long as Mr. Blakesley was wearing his helmet and leathers. Okay, so the leathers are this basically leather jacket with brass buttons on the front and on the sleeves, so he's not going to burn himself with sparks while he's working. So he was wearing his leathers and his helmet when he was working. So he had permission not to wear the vest then. More importantly, he was doing his job as a welder. What they told him when he got there was, you're going to cut these 20-foot sections of pipe in half. And after you cut them, then we'll lower them into the pit where we're working, and then you can weld them back together. And the reason he had to cut them in half was because the pit was so small that it wouldn't take a 20-foot section of pipe. So they had to, Mr. Blakesley was supposed to cut them in half so that then they could lower him into the pit and then he could weld them down there. So he was doing his job as a welder. That's what he was doing. He was cutting this first piece of pipe.
Mr. Case?
Yes,
Does
sir.
the record reflect whether there were available non-flammable, high-visibility vests?
Well, the testimony from Joseph Barger, who is the foreperson for BTC, was this. Quote, here's the question to Mr. Barger. And if Chip Gallowix or another railroad representative had said, nope, I need you to wear that vest, is that something you guys would have to comply with? Answer by Mr. Barger, it would have. And then we, BTC, we would have to get them fire retardant vests. That was the answer.
So apparently there is such an animal as a fire retardant, high-visibility vest.
Yes, that's absolutely true. Now, the ones that burst into flames, they're cheaper. And Mr. Blakesley's employer provided him with a truck, and in the truck was a flammable vest. So he gets to the job site, and he realizes there's a safety issue here. So he does what he's supposed to do. He calls it to the attention of the safety officer in charge, which is Mr. Gallowix. And jumping to the trial court's error, the most glaring error in the case is her finding that Mr. Gallowix had no authority on the job site. He was just there to watch the train tracks. Well, that finding is contradicted, first of all, by the court's own finding that the flagger told Mr. Blakesley, you don't have to wear that vest. Keep it off, as long as you've got your leathers and your helmet on. Well, if he didn't have any authority, how could he tell that to Mr. Blakesley? I mean, there's an obvious inference. He had the authority. But there's also direct testimony about his authority. Mr. Barger, again, testified, quote, it's their facility. You are in their right-of-way. So you have to do something they require you to do. If they tell you it's unsafe or something, then you have to follow what they say, they being the railroad. Mr. Blakesley testified to the same effect. He described an online safety orientation course that is put on by the railroad, BNSF. And everybody on that job site has to pass that safety orientation course and get a badge that they wear to work just to be on the job site. And then the first thing they do when they get there is they report to the flagger, who's in charge of safety. And Mr. Blakesley testified, quote, the flagman has overall control. So
Mr. Haslett,
yes.
I want to go back to your disputed fact. So it's your contention that this injury occurred as part of the welding and cutting. It wasn't independent, because when I was reading the depositions, it appeared that he got out of the pit and followed the pipe.
He was never in the pit.
Or he followed the pipe after he made the initial cut. But that's all part of the welding and cutting process?
Yes.
That's
He
the
has to
evidence?
roll the pipe in order to cut it. So this pipe is 20 inches in diameter. and it's 3/8 of an inch thick and 20 feet long. I mean, it's heavy. So it's mounted on little wooden blocks when he gets there. So he has to cut it right in the middle. So he cuts it, but he can only get 180 degrees of the pipe cut. He can't reach what's underneath and close to the ground. He's using a torch. So in order to make that last cut, he has to roll the pipe off the dunnage, which is what he did. He rolls it off, and it rolled too far, so he had to push it back.
But isn't all this just a causation issue that has nothing to do with whether or not there's a duty? In other words, if there's a duty, the defendant can defend on the basis that even though maybe there was negligence, it didn't cause the injury. But it just seems to me here that there's an awful lot of conflation between defenses and the initial determination of whether there's a duty or not. Do you agree with that?
Yes, sir. So the last thing I want to talk about before I yield the floor so you can hear from Mr. Widman is the Smith factors. The trial court was supposed to apply Smith because this is a misfeasance case. So the first factor is what risk is there if Blakesley doesn't wear the safety vest? Well, the trial court never commented on that, made no finding at all. The second factor under Smith is the foreseeability of injury versus the social utility of the actor's conduct. So this is her finding at page 10. The flagger had no reason to know the likelihood of harm to the plaintiff. What? I mean, the rule is there. It's his rule. You got to wear a vest. If you're not wearing it, you can get run over by this machine. The trial court, the next thing she's supposed to consider is the social utility of Galowicz's conduct. Well, it had no social utility, but she didn't make any finding on that. So now we turn to factors 3 and 4 under Smith. Those concern the burden of guarding against harm and the consequence of placing the burden on the actor. Well, as we said, there's no burden on Burlington Northern. The burden's on BTC to get this man the right vest. His employer gave him the wrong vest. He did his job, reported the safety issue, and Galowicz told him to work without it. He should have said, BTC, get this guy a vest, because he's not working here without it. That's our rule. The last Smith factor is, the sort of catch-all, any other factor that's relevant. And the trial court here said it's against public policy to hold someone responsible for conduct over which they have no control. That's her order at page 10. Well, that's simply wrong. The flagger admitted he controlled whether workers wore vests or not. And the flagger's misfeasance was telling Mr. Blakely not to wear the high visibility vest.
Mr. Case, before you move on or conclude your argument, what was the sequence of comments? Was it Mr. Blakesley that asked, do I have to wear the safety vest while I'm welding? And
Okay,
then the flagger responded?
Here's what happened. He gets there at 9 o'clock because he was told, don't get there at 8 for the safety meeting. We don't want to pay you to be here for an hour at a safety meeting. So you get there at 9. So he gets there. Galowicz has already had his safety meeting with the crew. So Blakesley does what he's required to do. He reports into Galowicz and says, where do you want me to park my truck? So Galowicz, who the defense claims had no control over the work site, says, park your truck over there next to the pipe inside the fence.
You're deviating from my question.
I'm sorry, I didn't mean to.
My question was simply, what was the sequence concerning the wearing of the vest?
Okay, well, that was the first part of that conversation. So then Galowicz said, because Mr. Blakesley didn't have his vest on, Galowicz said, you've got to put on a safety vest. And Mr. Blakesley said, well, the vest I have, and he showed it to him, is flammable. It's made of rubber. So if I wear this, I'll catch fire. So Galowicz said, okay, well then you don't have to wear it while you're wearing your leathers and your helmet.
I.e. when you're welding.
Yes, but the way the way the conversation is actually quoted by Blakesley is, you don't have to wear it while you're wearing your leathers and your helmet. If you take off your leathers and your helmet, then you have to put it on. That's in the record. But it was Gallowix who started the conversation and told him, put on the vest. So I'm almost done here. I'm on my last page. So, as I said, Blakesley's the only person required to wear fireproof clothing. His employer issued him a flammable vest, which left Mr. Blakesley facing two hazards. Should he set himself on fire while welding or be in danger from the track hoe? So without an orange safety vest, he goes to the crew that's operating the track hoe and says, look, I've got to work nearby. Will you cover me? And they said, yeah, we got you covered, don't worry. So because he didn't have the orange safety vest, they didn't notice him, and the track hoe ran over him. So the trial court refused to hold, supervisors are responsible for safety. The BNSF supervisor should have been held accountable for misfeasance, and we ask this court for reversal and remand for trial before a different judge. Thank you.
Thank you,
Before-
Mr. Case. Oh, go
Can I
ahead.
just add-
Come on back.
Okay.
Before a different judge?
Yes, this is the second time we're here on this case.
Do you have any authority that would support that request?
Well, I've seen it suggested in other opinions that the Court of Appeals suggested we would suggest a different judge hear this on remand.
Are you contending bias or prejudice?
Well, yes.
Did you
This-
move to recuse?
Well, no. We came up once, first time. The first time the trial court said there is no evidence that BNSF authorized Mr. Blakesley to take off his vest. That was her finding. And the Court of Appeals, the first division that heard this, said trial court made a mistake. So go back, revisit that conversation, and see if there's a duty of misfeasance or nonfeasance. So it goes back. The second time she says, with all the evidence in the record about all this authority that Gallowix says, the basis of her ruling is Gallowix had no authority. So now we're in extra innings, and there's already been 2 strikeouts. So if it goes back to the same judge, we'll be dismissed, and then we'll be back here, which I'm sure you don't want to see us again.
Right, thank you, Mr. Case.
Thank you.
Bailiff, could you add an extra 2 minutes to counsel's argument?
Thank you. Brian Widman, 26299 for BNSF Railway Company. May it please the court. The first appeal in this case resulted in the contractor defendants being dismissed and a finding that BNSF was responsible for a section of property outside the fenced area, but only to the extent it affected train tracks or train traffic. That demarcation of authority is correct. The rule that counsel began his argument with, there are rules for wearing the high visibility vests. BNSF has its rules for BNSF work, which is the protecting the track, protecting the foul of the track. That rule is that once you leave BT Construction's work site, you better have that vest on. BT Construction also had a rule contracted into the stream of contracts for the Gold Line. High visibility vests must be worn.
Mr. Whitman,
Yes.
as I suggested earlier, I am really concerned that there's conflation here of defenses and the question of duty. And in other words, whether or not there was comparative negligence, at least the way I understand the law, has nothing whatever to do with whether or not there was a duty. Here the argument is that the flagger gave directions to the plaintiff that were unreasonable, and the only question before us, I believe, is was there a duty that required the flagman to act reasonably? If there was, everything else is for the trial court, not for us. And that's not frankly the way I read your brief. I read your brief as challenging causation, challenging comparative negligence, everything but the kitchen sink.
With regards to what I am presuming to be what you read as the causation arguments, those arguments were made, for example, that Mr. Blakely himself recognized that BNSF did not have that duty. He did not walk across the track to speak to the BNSF flagger, Mr. Gallowitz, who was in his truck doing his Form B and train responsibilities. But instead, he walked over to the spotter and the excavator and had a contract, what he called in his deposition, a binding agreement that they would watch out for him when he posed the question, hey, I need to be over here. Should I wait or should I proceed with trying to roll this tonnage? So there is a bit of causation within that, but that within the Collard case, which admittedly is not a Collard v. Vista Paving, it is not a misfeasance case, but is a case that applied the same tort factors, which concluded that, or as part of its conclusion said that it would limit the scope of a duty such that it does not arise if the contractor had a reasonable good faith belief that another authorized entity will promptly eliminate the hazardous condition or provide sufficient warning of the danger. Those considerations apply to the factor of
Did the flagger have the authority to tell the plaintiff that he didn't have to wear a high visibility vest?
he did not have authority within the BT construction work site, but he did answer that question.
So he acted in excess of the authority granted to him by the railroad?
All of the testimony at Appendix B to the amended answer brief shows that when Mr. Blakesley arrived at the site, and he was not instructed by BNSF to arrive at any specific time, nor is there any evidence in the record that he was supposed to go speak with BNSF. When he did arrive, he spoke with BNSF, and Mr. Gallowitz went through his normal briefing about train safety, and that's described in Appendix B, that he explained his Form B procedures and explained about the vests, no use of cell phones, etc. And it was during that conversation that Mr. Blakesley raised the issue of my vest. What about my vest? And he says, well, that makes sense to me, and I'm not trying to change the testimony, but he basically said, and I'm paraphrasing, it's flammable, that makes sense to me, but as soon as you leave that enclosure or walk about, then you must be wearing the vest.
The flagger could have said, go talk to the job superintendent, I can't answer that question, right?
Correct.
But he chose not to do that.
He did not, you're correct, he did not say that. I think that the flagger, when you read all of the testimony, Mr. Gallowitz was thinking about his responsibilities for BNSF, but in fact he did say, yeah, I agree. I'd like to address the causation issue, if you will, but I think it also folds into the factors for duty about was he welding when this accident occurred? Well, the record shows that, and it's in his own words, that he had completed half the weld, just as counsel stated, and was releasing the pipe to roll it, to weld on, or cut, on the bottom. That rolled away from him much further than he anticipated. So he stopped his welding and had to walk over. I think he says in his deposition testimony that it rolled 2 to 3 or 3 to 4 times, it was an estimate, but it rolled away from the welding site. The welding area was in the corner of this fenced.
But that's exactly my point. Isn't that a question of whether or not the negligence by the railroad caused the plaintiff's injury, not whether or not there was a duty not to make what appears to be a fairly reckless statement?
It goes to when the authority ended. Going to the point of what the initial question was. The initial question posed by Mr. Blakesley, in his words, was whether he should wear it while cutting and welding. There was no discussion about how else he was going to be doing his job. I talked to him about the flammability of my vest during the welding and cutting of the pipe. And then so that's how the whole conversation was prefaced, when welding and cutting. Now, they didn't get into the details of, okay, well, what if this rolls over? But within the record, there's ample evidence that everybody knew BT Construction was in charge of the fenced-in enclosure and everything that went on in there. BT Construction had an excavator and a spotter standing right in front of the excavating machine, in between the machine and the pit. The pipe rolled right over to the excavator's tracks. So there's, I think, a reasonable expectation. It's foreseeable that, well, if he's not welding in this area and is walking around, either he would put that on based on the conversation, he would put the welding vest back on, and under the likes of Collard, that another entity right there who Mr. Blakesley went over and had his binding agreement with, that they were going to watch for him. So it's foreseeable under a duty analysis, and that could also be evidence of causation or lack thereof as well.
But do you agree that the question, really the only question before us, is whether the flagger had a duty to not make the statement that he made? Isn't that the issue before us, and everything else beyond that, if we find that he had such a duty, everything else is for the trial court or a jury?
Under misfeasance law, misfeasance is active conduct that injures others. Unlike assumed duty law, which is a mixture of fact and law to determine if there's a duty under justice or under the justice case, under misfeasance, it's a matter of law. And here, I think that the foreseeability, when that conversation first occurred, the BNSF employee was responding, and he responded, if you read all of that testimony, he's discussing about his roles, and well, if you're out of there, you've got to wear the vest. Whether or not he had a duty to say, no, I can't answer that, I don't think he did answer it for BT Construction. Presumably, Mr. Blakesley would have also gone over and cleared with the project superintendent, Mr. Barger, as to whether or not if it was okay with him.
Mr. Williams, as I understand the definition of misfeasance, it's not just active conduct, but it creates a new risk of harm. And what I'm hearing you say is there was no legal authority for the flagger to make this statement, and it did in fact create a new risk of harm, which was the injury that was sustained. So why isn't that, as a matter of law, a legal duty on behalf of BNSF?
Well, I think that akin to the assumed duty law, where a trial court or appellate court will look at the scope of the undertaking and the risk that was discussed, here, if there was a duty, it was to address this concern about flammability. And that duty, if there was one, was discharged. There's a flammable vest for a welder, doesn't make sense. But the scope of that conversation was only about welding and cutting. It wasn't a general, it didn't didn't turn BNSF into a guarantor of project safety for everything then that Mr. Blakesley did at the project site. If there is a duty, that duty would have gone only to concern about fire and fire safety, which was discharged. And he was not injured by anything regarding fire, any fire danger, or any train danger. It was BT Construction who did not spot him as they promised they would. And I think also there's another important piece here with regards to authority over the job site, In the two leading cases on misfeasance, which is the Smith case that we've discussed and Montoya v. Connolly Towing, in both of those cases where the misfeasant defendant, or the defendant was deemed a misfeasant, both defendants had complete control over those areas. Smith, by virtue of his contract and signing loan documents, by virtue of getting the permit, and by his own representation that a general contractor is in charge of site safety, he was deemed in charge of that whole site. Here, BT Construction would be that contractor. They were in charge of the site safety within the fenced-in area. Turning to the Montoya case, in that case, that was involved a car and a loose lug nut, and at all times, relevant times, that car was on the possession, or was in the land of Connolly's Towing, who had authority over the yard, the land, and then what they were telling their customers, or the person coming to pick up the car, which caused the injury. Here, you have BNSF in a very limited role with regards to construction. They wanted to make sure their track wasn't damaged, make sure none of the workers had injury from train, and then other train-related duties, stopping the train if necessary. BT Construction, however, was in charge of the fenced-in area. And those issues for each of the issues to be considered, especially when you look at fairness under contemporary standards, as foreseeability includes whatever is likely enough in the setting of modern life that a reasonably thoughtful person would take it into account in guiding his or her practical conduct. Now, here we have Mr. Blakesley, a reasonably thoughtful person. When he realized, oh, I'm not welding anymore, I need to go and move this, roll this back away from the excavator so I can weld again, he did not go over to BNSF, as I discussed earlier. The record is clear that he walked over to the spotter and the excavator, and their conversations are in Appendix B.
But isn't that arguably comparative negligence?
It's also foreseeability from BNSF's position under contemporary standards. For example, in the Colliard case, looking at a contemporary standard, they got rid of the completed and accepted rule and looked at, well, was there somebody else that this was going to be handed off to? And I think that would apply to misfeasant law too, as narrowly construed to the actual discussion, which was the risk of fire danger.
Well, applying contemporary standards, isn't it a contemporary standard that someone who, at least with arguable, whether he in fact had it, I can't tell, but arguable control over a job site does not tell one of the workmen to violate a fairly fundamental rule regarding wearing a high visibility vest? Doesn't contemporary standards tell us that there's a duty not to say something like that by the supervisor?
With regards to the whole project operations, if he was in BT Construction shoes, yes. From the perspective of BNSF and a question posed to him, which is really not his job, and he knew that. Contrary to what was said earlier, Mr. Blakesley knew that BNSF was basically the railroad coordinator, and that's within Appendix A as well. He knew that the safety issues were being handled by BT Construction. So with regards to his position as the BNSF insurer of BNSF's property and safety regarding trains, his position was, it's fine, it makes sense that you don't get hurt by fire danger, but as soon as you do anything else, you put that on.
If we reverse the judgment, what's your position on counsel's request that we direct that a different judge be assigned?
First of all, that was not raised until a couple minutes ago. Secondly, Judge Starrs is just receiving an award this week, as I understand.
Well, what does that have to do with anything?
Well, I think she's a very, very good judge, and I don't see, there's been no claim of bias until now. It's just result-driven. I think the court order is quite fair and goes through these circumstances that we've discussed here today. And I don't think there's any bias or malice that has been evidenced anywhere in the court's writings. And I don't believe we've appeared, maybe for a case management conference, but nothing in the court's writings and nothing that comes to mind of in person of any type of bias or malice towards the plaintiff.
Thank you, Mr. Whitman.
Thank you.
Thank you, both counsel, for your arguments today. We appreciate them. This case will stand submitted and opinion will issue in due course. That concludes our 1:30 docket today, and we will now be in recess. Counsel or bailiff, you may announce.